Most people who buy rural land make one catastrophic error before they ever sign closing papers. They never verify legal access. No recorded easement means your dream property could be legally landlocked, unreachable without trespassing on a neighbor. That single oversight has voided sales, triggered lawsuits, and left buyers owning acreage they can't even drive to. Today, we're breaking down exactly how to avoid it, using our own purchase of 160 acres of off-grid wilderness as the case study. We didn't inherit this land. We researched it, verified it, and walked it before we ever made an offer. This is the real process, legal frameworks included, not a highlight reel. If you're serious about buying land the right way, subscribe to Land Guide USA. We publish state-by-state blueprints for verifying title, access, water, and zoning before you ever risk a deposit. Zoning ordinances dictate what you can legally build. Rural parcels often fall under agricultural or resource conservation zoning, which restricts subdivision, structure size, and sometimes even seasonal occupancy. Every county interprets these ordinances differently. We pulled our parcel's zoning classification directly from the county planning office, not from the listing agent, because listings can be outdated or simply wrong. An easement grants legal right to cross another person's land. Without a recorded ingress-egress easement, a private road shown on a map may have no legal standing at all. We ordered a full title search before closing. This revealed 2 existing easements, 1 utility right-of-way and 1 shared access road with a neighboring parcel, both properly recorded. Mineral rights can be severed from surface rights entirely. If a previous owner sold subsurface rights decades ago, someone else could legally drill or extract on your land. Our title company confirmed mineral rights were intact and transferring with the sale. This single line item can dramatically affect long-term property value and future land use. A percolation test determines whether soil can support a septic system. Without a passing perc test, off-grid living without municipal sewer becomes legally impossible on that site. In many Western states, water rights are separate from land ownership entirely. We confirmed our parcel included appropriative water rights tied to a seasonal creek before finalizing anything. Here's a real-world scenario common to off-grid buyers. A family purchases 40 acres advertised as road accessible, only to discover the access road crosses private land with no recorded easement. The neighboring owner blocks the road. The new buyers now face a costly quiet title action or an easement by necessity claim, both requiring attorneys and months of litigation. This is why we insisted on a licensed survey and a title commitment letter explicitly listing every easement, before we wired a single dollar toward escrow. A boundary survey isn't optional on rural acreage. Fence lines, old deeds, and tax maps frequently disagree. Ours revealed a 3-acre discrepancy against the county's plat map. We required the seller to resolve the boundary discrepancy through a corrective deed before closing, protecting us from inheriting a future dispute with the adjacent landowner. Wetlands designations and floodplain status can restrict building rights significantly. We cross-reference FEMA flood maps and state wetland inventories against our parcel boundaries. Some rural parcels carry conservation easements limiting timber harvest or development permanently. We verified no such restriction existed by reviewing the deed's full covenant history. With title, survey, water rights, and zoning confirmed, we proceeded to closing with title insurance, which financially protects against any defect that surfaces later. Here is the exact verification checklist every land buyer should follow, regardless of state or acreage size. Step 1. Pull the county zoning classification directly from the planning department and confirm intended use is legally permitted. Step 2. Order a full title search and require a title commitment listing every easement, lien, and encumbrance in writing. Step 3. Confirm legal recorded access. A dirt path on satellite imagery is not proof of a legal right-of-way. Step 4. Verify mineral and water rights separately from surface ownership, especially in states where severance is common. Step 5. Commission a perc test if you plan to install a septic system for off-grid living. Step 6. Hire a licensed surveyor. Never rely solely on tax maps or GPS coordinates from a listing site. Step 7. Check FEMA flood zones and state environmental databases for wetland or conservation restrictions. Step 8. Purchase title insurance at closing to protect against defects that were not discoverable during due diligence. Educational note: this checklist is general guidance, not legal advice. Land laws vary by state and county, so always consult a licensed real estate attorney for your specific purchase. Because we followed this process, our 160 acres closed clean, verified access, intact mineral rights, confirmed water rights, and a resolved boundary line. Today, that verified ground is home. The diligence that felt tedious during escrow is exactly what makes it defensible, buildable, and truly ours. Zoning, easements, mineral rights, water rights, surveys, and title insurance. These 6 pillars separate a secure land purchase from an expensive legal problem. Tell us in the comments which state you're researching, and any land laws specific to your region we should cover in a future deep dive. For more state-by-state legal breakdowns and verified land buying blueprints, subscribe to Land Guide USA. Do your diligence, protect your investment, and we'll see you in the next one.